BS versus PM in the Johannesburg High Court. This is an appeal judgment. The judge Van Vieren A.J. penning the judgment, Dlamini J. concurring. For those following along in your bundles and on your summaries, it's bundle page 52, summary page 5. And the citation, I'm not going to give the case number again. It just becomes too much of a tongue twister. It's 2024 ZAGPJHC 508 is your SAFLI reference. And this is BS versus PM. Now, what happened in BS versus PM was that the appellant, Mrs. S or Ms. S, appealed against the decision of the Randburg Regional Court, which granted absolution from the instance at the end of her case in a dispute regarding the existence of a Tsonga customary marriage with Mr. M. Now, it's a very interesting factual matrix in this case, and I would urge you to read the whole factual matrix and the ratio of the court. The aspects looked at, customary law must be applied by the courts when applicable, subject to the Constitution and any relevant legislation. That's obviously in terms of the Customary Marriages Act. Compliance with Section 3.1 of the Recognition of Customary Marriages Act is essential for the validity of a customary marriage, and for a valid further customary marriage under Tsonga law, spousal consent is required. Mr. in this instance was previously married. There was some controversy over whether it was disclosed to Ms. in this instance, and it was quite interesting to see how the court dealt with it. A notable quote was referring to MM versus MN in another 2013 for SA 415 Constitutional Court, which was essentially the final word on the issue. And paragraph 51 of the judgment, the court refers to MM versus MN. In the majority judgments penned by Vermeulen J, Kampepe J, and Squiggia J, the Constitutional Court concluded that Tsonga customary law had to be developed to include a requirement that consent of the first wife is necessary for the validity of a subsequent customary marriage. The court's reasoning included that this conclusion is in accordance with the demands of human dignity and equality. The court in BS versus PM, following that judgment and finding that the consent of the first wife was necessary and essentially upholding the decision of the Randburg Magistrates Court to allow absolution from the instance. So no valid customary marriage in this instance, because under Tsonga customary law, it was necessary to prove spousal consent by the prospective husband's existing wife, which was not given. I can imagine a very awkward conversation between Mr. and his existing wife when she found out that he had purported to enter into a further customary marriage.